Good morning. It is 10:42 a.m. on the 23rd of September 2020. My name is Aaron Hunt. I'm a partner here at Stace Hammond and I head up the Migration Partners team. Now this video should not be taken as being advice. This is merely our commenting on changes with immigration in New Zealand. And today we're going to talk a lot about the possible interpretations of what the Minister of Immigration, Chris Farfoy, has stated in the past few weeks, and along with what's been released in press releases. But which we have yet to see being put into place, because there's a lot of it that is not clear. If you want actual advice, get in contact with us by email, by phone, or through our website. We've seen a lot of confusion around partnership visas, both in comments on our videos and also on some online forums. This hasn't been helped by mixed messages from Immigration New Zealand, the Immigration Minister, and certainly not helped by the media, who have a lot of difficulty in understanding immigration rules. So we're going to look at it in a bit more depth and look at several things that are in place now and what we are expecting in the next month in early October. As a result, this is going to be a long video, so we'll leave some indicators below of where new topics start. However, there is a lot of overlap and one big section in the middle, so it's going to be difficult to split that up, and it might benefit to actually watch the whole video. Also, please subscribe and click the bell if you want to hear about future videos we put out there, and also like the video. It does help us get into YouTube's algorithms and let people, more people know about the video. First thing is two quick bits of news of changes that have come through in the last few weeks. First thing is a quick update as to visitor visas for those in New Zealand. Now, several weeks ago we reported that Immigration New Zealand had granted a 5-month visitor visa extension to most visitor visa holders in New Zealand, with a few exceptions. Go see our video on that if you want more information. Now, this was applied to visitor visas that had expired before the end of October, which included people who had already been extended to September 25th. Unfortunately, Immigration New Zealand took a few weeks to get those changes in place. As a result, several people would have officially, at least in the immigration systems, showed as becoming unlawful. Others were granted interim visas, even though their actual visa didn't expire until sometime next year with the extension granted. We heard from Immigration New Zealand on Monday that there had been 13,000 visa extensions granted on Sunday, and the rest were being done on Monday. Now, we spoke to them again yesterday and they found that there had been a glitch. So those who had come from visa waiver countries, it appears, did not get the extension as they were supposed to. INZ are aware of this and it is being worked on, and individual files are being raised with the technical team there. I spoke with them again today and those issues have not been resolved, and those clients, or those applicants who from visa waiver countries and should have had the extension, haven't had it applied yet, at least not the ones that we raised with them, but they are working on it. Second thing is, yesterday we got a email from Immigration about some further changes to visas. That was in relation to regional seasonal visas. Now, bringing the wording up for that so I don't forget the exact wording. That basically came down to those of you who had received a regional seasonal employer visa. That was a visa to allow you to work in agriculture or horticulture or viviculture, and you had become stranded in New Zealand. You are now able to apply for another RSE visa. Those of you who are on working holiday visas, who have your visa expiring between the 1st of October through until March 2021, they don't say when in March, but at some point in March next year, when your visa expires, you'll be granted a SSE, which is basically another version of the RSE, which allows you to work until 31st of June 2021 in the agricultural, horticultural, viviculture space for an employer who is allowed to take an RSE or an SSE employee. You will get that visa extension granted, or that new visa granted automatically. If you don't want that visa granted, you must apply for another visa type before your current working holiday visa expires. They're also going to be allowing exceptions for 30 veterinarians who work with livestock and larger animals, 570 6-month visas for those working in deep water fishing, and also 210 visas for those who work with machinery in the agricultural, horticultural, viviculture sector. Those are all exceptions that are going to be granted to allow people to come to New Zealand to work in those areas. That was yesterday's update. Now, we are going to mention quickly the Love is Not Tourism campaign that's going around the world. There is a New Zealand branch to that, and I will link to their website in the description below. On that website is also a link to a Facebook group. It's actually a very active Facebook group, and I've been on there and made a few comments there, and it seems to be a good place to go to discuss if you in a situation where you have a partner who's a partner of a New Zealand citizen or resident and you're stuck overseas due to the border closures. There's some good support people in there, so definitely check that out if that's your situation. Go check out their website and check through to the Facebook forum that's linked to it. Now, before we get into the actual discussion of the partnership visa situation, we're going to look at terminology. We looked at this previously. We'll look at the current situation with partnership visas and for those who are partners of residents, citizens, visa waiver countries, not visa waiver countries, applications, no applications, that sort of thing. And we're also going to look at culturally arranged marriages. But before that, back to terminology, we want to just touch on two things again we did mention in the last video, and it's terminology used by Immigration New Zealand, and also seen it being used in the press releases and in interviews with the Minister Whāwhoi. And so we're going to also link to those interviews and to the press releases in the description below as well, so you can see what we're referring to. We will also make references to the operational manual, which is sometimes immigration called the instructions. Now, these are the rules that Immigration New Zealand follow when they're looking at an application. If we provide a reference to the manual, we'll provide a letter followed by a number. For example, E4530, which will be seen as E4.5.30 is how we typically would write it down. And this is a reference to the operational manual. Now, the operational manual can be viewed online by everybody, so it's not sort of a private area just for us. You can all see it. We'll provide a link below. It is quite comprehensive, so don't go in there thinking you'll read the entire thing, because a lot of it will not apply to your situation. But it is what Immigration New Zealand are looking at when they do look at an application and they grant or decide it, or what rules must be followed. And it's what they will refer to in their letters to you and what we refer to them when we're going through the process with them. Now, the first words we want to touch on again were the words apply, processing, granting and decision. The Minister of Immigration, Chris Whāwhoi, mentioned the word processing a number of times in interviews, and the media picked up on this as meaning that certain people may be able to apply for certain visas. Now, the word processing itself means that Immigration New Zealand will look at an application that has been made, check the documentation, do the typical process that they do with an application. The word processing does not mean that someone can make an application. It merely means the application that has been made will be looked at. It also does not mean that an application, the decision will be made on an application that a visa will be granted. An application can be processed without a visa being granted, and Immigration New Zealand have said that recently, and actually said it in their recent release. They'll work up to a certain point and then they will stop. So this distinction is very important when looking at what Immigration New Zealand and the Minister have said. It doesn't necessarily mean the Minister says that that won't take place, but we need to look at the context, and we'll go through that. The second is the word partnership, which in the operational manual is also referred to, sometimes referred to as relationship, which is, we think it's confusing. They should stick to just the one word rather than using the two. Now, first we note that those applying under a culturally arranged marriage have different rules, which we'll look at further in the video. Now, under WF2, partners of New Zealand citizens and residents, and for sake of those of you in that situation, under E4530 for partners of temporary visa holders, partners need to be living together in a genuine and stable relationship. Now, if you're in a relationship but not living together, INZ may find that you are not entitled to a partnership visa. Now, COVID-19 has complicated things as people have been separated due to closed borders, and INZ have been reasonable about this and how they're handling that. However, if you and your partner were deliberately living in different places, and no, not due to COVID-19, but by choice, then it would likely be questioned as to whether you were living together in a genuine and stable relationship. The together part is the important part there. This is where Immigration New Zealand would usually look, or possibly look, at a general visitor visa to allow someone to enter New Zealand to start living with their partner if they believe there actually was a relationship, for the sake of a better word, but they weren't actually living together in a partnership. Now, moving on to the actual partnership applications, a bit more information about what's been released on that and sort of how we're interpreting it, at least for now. One of the big questions, of course, people are asking and miscommunicated by the media is if they can file a new application under partnership. Now, this all relates, the coming information relates to those who are partners to New Zealand citizens or New Zealand residents, not to temporary entry work visas. We will mention those a little bit later on, but this for the next section definitely to do with citizens and residents. The operational manual doesn't provide much guidance on where applications are allowed to be made or who's allowed to make them. Now, A16C does give a list of priorities as to what priority applications are to be processed by immigration in, and it does list the partners of New Zealand citizens and residence holders in A16C. However, A16D then provides for sort of everybody else. So partners for applicants for temporary entry visas offshore covers those. So it does sort of cover everybody. It doesn't give any sort of distinction. So we have to look at what has been published on the Immigration New Zealand website in relation to the critical purpose reasons you can travel to New Zealand for what is currently in place. Now, we'll leave a link to this again in the description. This is where you actually go and apply for that border exemption. Now, that list includes partners of New Zealand citizens or residents who are travelling to New Zealand with a New Zealand citizen or resident. It also includes partners of New Zealand work visa holders or student visa holders who already hold a work, student or visitor visa, normally live in New Zealand, and whose partner is currently in New Zealand on a work or student visa. So that is the current situation. So partners of New Zealand citizens and residents, as it currently stands, can apply for an exemption to come into New Zealand with the New Zealand partner, with the New Zealand citizen or resident partner next to them, not separate, where those who already hold a work visa from being a partner with a work visa or a student visa holder and who normally live in New Zealand can enter without their partner if their partner is in the country, which is a strange separation to make, but that is what the rules currently state. Now, changes are being made, and we had the release from Immigration New Zealand on the September 15th, which provided us more information and sort of led to a lot of hope for people in many of your situations. And INZ in that release had sort of a frequently asked question section. I'm going to just quote a bit from that. Now, the question they had in that was, can I apply for a visa if I am offshore? Now, they state in that for a period of 3 months from August 10th, the government suspended the ability for people offshore to apply for a temporary entry visa. The following offshore temporary entry visa applications are not affected. Now, the first thing in that list is relationship-based visas for partners and dependent children of New Zealand citizens and residents. So, from this email, this release, applications for partners of New Zealand citizens and residents are possible, though, as we've just said, this is aimed at people looking to travel to New Zealand with their New Zealand citizen or resident partner. It doesn't state it there, but if it's coming down to what is currently not affected, then that would be what that covers. Now, however, the Immigration New Zealand system, for those who have used it recently, requires an ITA to be provided, an ITA number, and so that an exemption must first be sought through the Immigration New Zealand website. So this is through the Request to Travel to New Zealand page, which we'll link to below. In that form, you can choose the option of being a partner of New Zealand citizen or resident, and it will also ask if you're travelling with your partner, which is still the requirement. However, being a partner to someone in New Zealand was, unless there was an exceptional reason, not typically allowed as an exemption. So if you're with your partner, you can get an exemption. If you're not with your partner, you can't get an exemption, but yet the email is stating that actually, no, you can. So there's definitely a confusion there which isn't clear. Now, we should just mention that in a discussion with Immigration New Zealand, they did mention the practice of New Zealand citizens and residents who were leaving New Zealand, going to where their partner was, and then seeking the exemption to bring the partner home where they were travelling with them. Now, INZ would not agree or disagree with this process. They wouldn't say it was bad or good. They did mention that the exemption was not guaranteed, that if it was granted, there would be the cost to the New Zealand citizen or resident to return, the cost of quarantine, and that travel back to New Zealand could be difficult, as many of you are finding. It may mean months outside of New Zealand, so while it is an option, it isn't one that Immigration New Zealand would support or disagree with. And we agree with that situation. It's very much looking at it on a case-by-case basis. Now, in early October, the right to apply for an exemption is being extended. So that's how things are currently, which even that isn't that clear. But it is being extended so that partners who come from visa waiver countries can apply for a critical purpose visitor visa to travel to New Zealand without needing to be with the partner. So this would instead of needing to apply for a partnership-based visa, they could get the exemption, which allowed them to come to New Zealand on a critical purpose visitor visa, would give them 6 months to come to New Zealand, give them 6 months in New Zealand, during which they could apply for another visa. Now, it isn't clear if partners of citizens or residents who aren't from non-visa waiver countries will be allowed to submit an application for a partnership visa. From the wording of the Minister's comments and from the 15th of September release, we are assuming that they will be. However, the word processing is used and not application. So while the option exists on the exception application form, that doesn't indicate that an exception will be granted to allow a critical purpose visitor visa application to be made. The right for those from visa waiver countries to apply for the CPVV may just be to allow them to use what should be a simpler and faster application process. From the wording of the 15th September 2020 release, it would appear that partners New Zealand citizens do not need a border exemption. However, for anyone who has tried submitting an application, the system itself states that you may only apply for a visa if you have submitted a request for an exception and you've been invited to apply for a visa. So the statement that partnership visas for partners New Zealand citizens and residents are exempt, which is made in the 15th of September release, does not match the current situation. So this may be in fact be a reference to what is coming through in early October, as the system itself currently says that you cannot apply. So again, it is very confusing that these things just don't line up. Now, in the interview with the Indian Weekender, which we'll link to below, the Minister was asked about partners of citizens who are coming from non-visa waiver countries and why there was a discrepancy. And he stated, I have some good news, as I can confirm that Immigration New Zealand will start processing partnership visa applications from non-visa waiver countries from this week. Now, this was, I think, last week. Now, notice that he used the word processing. There's no indication that applications from non-visa waiver countries will be permitted. So from the releases out of Immigration New Zealand, where they specifically allow visa application from early October, those are for visa waiver applications. It would seem that those from non-visa waiver countries may not be allowed to apply. We need some clarity from the Minister on this, especially as use of the word processing. So what was made clear from the press release, and perhaps a little less clear from the Minister's interviews, is that processing of applications that have already been made have restarted. And I know a lot of you are happy about that. Those of you who applied some months ago, applications were all paused as they stopped all application processing, and those are now being restarted. This includes visitor visa, work visa, and residence visa under partnership applications where they are partners with New Zealand citizens and residents, irrelevant of where the applicant comes from. So the letter from 15th of September does state that if granted a visa, these visa holders will be exempt from New Zealand border restrictions. The visa holder can travel to New Zealand and enter New Zealand without seeking an approval from us and will not need to submit an expression of interest for an exception to travel to New Zealand. So the expression of interest that you apply for online is the right to apply for a visa. They've already made an application for a visa, so they don't require that exception to be granted, and when the visa is granted, they can travel to the country. So what we can see is that those applications that were made before applications were stopped in August that fall under those categories can be processed and visas can be granted if the requirements are met. Okay, so this is a lot to get through. So just to clarify, partners from visa waiver countries, applications that are already in place will now be processed. If applications aren't in place and you're travelling with the partner, New Zealand partner, whether you're from a visa waiver or non-visa waiver, you can apply for an exception as long as you enter the country with that partner. From early October, partners of citizens and residents who are from visa waiver countries will be able to apply for an exception and then apply for a critical purpose visitor visa to allow them to come to the country. Those from non-visa waiver countries, it appears, will not be able to, but that's the thing we need to sort of clarify with the Minister. So, of course, when requirements aren't met and a general visitor visa may be available, the application processing will stop, as general visitor visas cannot currently be granted. So that doesn't mean that a GVV will always be granted if the standards of partnership cannot be met, but it is an option to Immigration New Zealand. That leaves us with a lot of unanswered questions. There are a number of scenarios that do not fit into the process above, which Immigration New Zealand need to provide information on. There is also no ready way to appeal a declined exception application. So if you apply for an exception to the border and they decline it, and there's a mistake in there is no process of saying, well, actually you've made an error here. And no, mistakes do happen really. We've seen probably just the one error actually, but yeah, one mistake that they've made, which we must admit once we raised it with Immigration New Zealand back to the person who made the decision, it was turned around pretty quickly back into an accepted application. But it did require us to go through and we did quite a long job in detailing where the error was and how they weren't following instructions. We wouldn't expect a lot of applicants who didn't have a lawyer to be able to do that or to know the operational manual well enough to do that. So it would be nice to see some way that they can have a second set of eyes, quickly look at an application and go, yes, that's correct, or no, it isn't, without needing to apply for another exemption application and pay the fee again and go through the process again. There's also been no indication as to when partners of temporary visa holders will be able to apply for the right to enter the country. Especially those who already have a visa granted. We are trying to find out more information, but it may be a situation where they'll get this current batch out of the way and then move on to your applications next. They hinted at the past, in the recent past, they've hinted at looking at doing this, reuniting families, but at the moment we're still waiting for Immigration New Zealand to provide more information on that. This brings us to the complicated area of culturally arranged marriages. Now, the Immigration New Zealand system was set up around the idea that people in a relationship are living together. However, this is not often the case. We have a number of applicants who, due to cultural or religious reasons, do not live together until they are married, both from Western culture, from certain religions that are that way, but also from a number of other cultures around the world where culturally arranged marriages are extremely common outside of Western culture. For this reason, Immigration New Zealand does have an allowance for visitor visas under partnership based on culturally arranged marriages. Now, E745.1 classifies a visa to enter New Zealand for purposes of a culturally arranged marriage as a partnership-based temporary entry visa application. So it falls under the partnership to a New Zealand citizen or resident allowance, which would mean that applications will be possible come early October, based on the changes that are being made. Now, culturally arranged marriages are not available to the partners of temporary visa holders, only to the partners of New Zealand citizens and residents. The actual requirement for a visa based on a culturally arranged marriage are defined in V335, and there is a few requirements there. The first thing we note is the first line of the last paragraph, V335.1d, and it requires this. This is what it says. Substantial evidence must be provided to demonstrate that the marriage follows an identified and recognised cultural tradition where the arrangements for the marriage, including facilitation of the selection of the persons to be married, have been made by persons who are not parties to the marriage. So it then provides a list of examples as to the evidence that can be provided. Now, substantive evidence. So substantive is a word that we rarely see in the operational manual, and it shows that Immigration New Zealand are looking for some good, solid, sort of high-level evidence. Their examples show communication between the parents of the couple or a go-between. They also list confirmation from independent sources that arrangements or ceremonies or both were in accordance with the cultural customs of the parties concerned. So an application with the parents just agreeing that it was a culturally arranged marriage probably wouldn't be enough to be substantive evidence. Immigration New Zealand are looking for much, much more. Many applications do not reach that standard, and when we've handled such applications, we've provided a lot of documentation to Immigration New Zealand to show that aspect. The application itself is made either before the marriage takes place, and if in that case, if the partner is coming to New Zealand to marry, or they need to marry within 3 months of their arrival in the country, or an intention to marry within 3 months. If they don't get married within that period, the applicant must leave the country. Or the application is made after they are married, but it has to be made within 3 months of the marriage taking place. So if you were unable to apply due to the prevention from making applications from offshore, and 3 months has passed since you got married, unfortunately we don't expect Immigration New Zealand to grant an extension to that date, and you need to look at other application types, which possibly could just be a visitor visa under partnership, could be an option. You'll be wanting to provide as much evidence as possible on the cultural aspects of the marriage. So for one applicant we handled previously, we provided 7 DVDs of the wedding, showing basically the majority of the wedding as recorded by a video crew, and covering hours, well, 18-20 hours of actual the ceremony over the several days. Also provided letters from religious leaders, documentation showing correspondence between the parties and other family members, sort of making the arrangements, making the discussions. Also doesn't hurt for the applicants to both write about the process, what they went through when they first met, what their parents said, and how these things worked. Immigration New Zealand themselves will have some familiarity with the overall process of what they're looking for, but that personal picture of what the person has gone through will definitely help to sort of build that picture up. The more information you can get and provide, the easier it is for immigration to provide the visa. So our process always basically is to provide as much as possible of relevant information. Don't just swamp them with irrelevant stuff. Look at what's relevant and provide as much as possible. However, they are difficult visas to get. Now, pre-COVID-19, where there were other options such as a general visitor visa, if the couple were separated, we would sometimes advise the clients to look at those other options. With the GVV currently being unavailable, partnership visas under the culturally arranged marriage allowance are a more desirable option, but they're also much harder to get. There's actually several other immigration lawyers quoted in one of the articles, and they agree that it is very rare for their clients to qualify under the strict definitions of culturally arranged marriage. And we have to agree with that view. It is not an easy path to take. People do get it, and I do see people online commenting that they have got it, but it comes down to how much evidence can you provide that it was a culturally arranged marriage and it went through the proper procedures, the ceremony in which taken place is done the certain way. It's a big application to make, so don't make it thinking it's going to be granted, because a large number aren't. Now that is it. Hopefully this has provided a little bit of clarity. We know that it is not the clearest situation right now. Hopefully we've answered some questions. If you have any more questions, let us know, make comments, we'll try and reply to them. If you actually want advice about your situation, we can't give advice through YouTube. Come to us directly through email, through phone, or through our website. What INZ have provided could be clearer. That's for certain, but they are in an unusual situation. They're providing information as they can, and quite often it's easy for them to release a one-page press release than provide 20 pages of changes to the operational manual. We are, of course, waiting for early October to see what the changes to the operational manual are, because they may show with better definition as to how things are going to work. Come early October, when we start seeing these applications go through, then hopefully we'll be seeing more changes made to allow partners of work visa holders to come to the country as well. But that may wait until after the election has taken place, because the election will change a lot depending on who gets through. That is about all we've got for today. I've got a meeting to get to, so kia kaha, stay safe, and we'll see you on YouTube, and we'll see you on the next video.